And now to Monday's not entirely unexpected decision from the state Supreme Court, a ruling based on an appeal that came from Let's Go Washington. The political group had asked the Secretary of State for permission to move forward with a referendum after the new income tax law, Senate Bill 6346, was signed into law. Let's Go Washington said, okay, lawmakers, you may have attached this necessity clause, making it an emergency, but we don't believe it really is. And so they went to the Secretary of State. Secretary of State Steve Hobbs denied Let's Go Washington and said, nope, there's a referendum proof clause attached here. You can't do that. They appealed to the state Supreme Court and on Monday received a denial, a rejection of that opportunity to move forward with a referendum. Um, in that ruling, though, there was some interesting language that was attached when they said, no, you can't move forward. They said, this is not happening now. But part of that, the court wrote, and we'll put up this graphic, you can see, they said, consistent with the words of the Constitution, we hold that engrossed substitute second bill or Senate Bill 6346 falls within the exception for laws that are necessary for the support of the state government and are not subject to referendum under Article 2, Section 1. The interesting part here is that the state Supreme Court is saying we have unbroken years of legal precedent here, our own court precedent that says if there's a necessity or an emergency clause attached to a bill, we'll kind of stay out of it. Basically, that's not our wheelhouse. We're going to let lawmakers determine whether or not it is essential to the budget and the governance of the state. So we'll stay out of it. So the thinking here for folks who are hoping to move forward to undo the recently passed income tax, or those who are backing the legal challenge, they believe that that language in the court's ruling on Monday bodes well for them. So former AG Rob McKenna had a conversation with him this morning. He is, as you may well know, leading the legal challenge alongside Citizen Action Defense Fund and former state Supreme Court Justice Phil Talmadge, who's a Democrat, basically saying, we believe that this is an unconstitutional tax on the income of Washingtonians based on the fact that Washington's Constitution says that income is your property and your property has to be taxed at a uniform rate. So you can't just single out a tax of 9.9% on income in excess of $1 million. So here again, a part of my conversation today with former AG Rob McKenna, kind of getting his take on the ruling that came down yesterday.
Well, it wasn't a great surprise, and I noted with interest the reference in the order to an unbroken line of rulings by the court that budget measures are not subject to a referendum. So that's good, and I trust the court will follow the unbroken line of rulings which have held that income is property under our state's very expansive definition of property, which is everything tangible and intangible subject to ownership. So that part was good to see. There is an unbroken line of rulings holding that budget bills are not subject to referendum. However, I think the plaintiffs here thought they saw a narrow path forward, which made this case different, and that is that this tax measure will not produce any revenue for the state budget until 2029. And therefore, they can argue that this bill is not necessary to support the state budget because it's not going to produce revenue in the state budget for several years. So that was their path forward. The Supreme Court disagreed, but it does this ruling does underscore that the legislature has, by including the language they did in the bill that the bill was necessary to support the state government, has worked very deliberately to keep this measure, this new income tax, away from voters.
So again, it's that darned necessity clause attached to the legislation that precludes voters from a referendum. And lawmakers are using that necessity or the emergency clause more and more in recent years. In fact, we wrote extensively about that in a series of articles last year after the legislative session ended when lawmakers in the minority were saying, hey, wait a minute. I think it was 183 bills during the 2025 session that had this, attached, which preclude lawmakers or preclude, I should say, voters from opportunity to weigh in via referendum. Now, remind you, it's easier to get a referendum on the ballot. It's about half the number of signatures required for an initiative. So it's a much heavier lift to get an initiative to the ballot than it is to get a referendum to the ballot. So precluding a referendum is kind of a big deal. So McKenna says, as far as he's concerned, this is a very concerning trend.
The increasing use, particularly of the first exception, the emergency clause language on every kind of bill you can think of, is a problem because it is systematically undermining the checks and balances which our voters built into the Constitution. It was the voters who said we want the power of initiative and we want the power of referendum, which is the power to subject an adopted bill to a public vote. And when they make wider and wider use of the emergency clause in particular, it systematically undermines voters' power to act as the legislature themselves and take a vote on the bill. And that's, I think, extremely unfortunate. There have also been other bills proposed that would also narrow and limit the, if they're adopted, narrow and limit the use of initiative and referenda. So this is a great concern. It is undermining the very system that our voters put in place many years ago.
So let's go Washington again denied their opportunity for a referendum right now, considering what their next challenge is going to be. It's going to be an initiative, but what that looks like, whether that's this year or next year, that remains to be seen. They're right now talking to some of their supporters and donors, no doubt, because it will take some deep pockets to get this thing moving forward in short order if they hope to get an initiative qualified for the November ballot. Of course, Let's Go Washington already has, a lot of attention that needs to be paid to their two other initiatives that are already qualified for the ballot this year. That is the initiative to restore parental rights and the initiative to protect girls' sports and keep boys out of girls' sports and girls' locker rooms and bathrooms. So they have a lot going on already between now and the November ballot. It is exactly 6 months from now until that happens, a very short period of time. So we're going to be all over that and let you know as soon as we hear any decision from Let's Go Washington on how they're going to proceed forward with the initiative campaign.